Thanks so much, Ray. Good morning, everybody. I'm impressed to see such a full house, notwithstanding the many events and dinners and open bars last night. It is really great to be here, and it's great to be back at the White Collar Institute. Thank you, Ray, for the introduction, and thank you for hosting so many DOJ folks out here this week. Ray told me that the Attorney General warmed up the crowd for me yesterday. I'm glad you laughed at that. I really appreciate the invitation to speak again at this gathering and to give the Larry Barcella Memorial Lecture. You know, my memories of Larry go back to my time as a newly minted AUSA in the DC U.S. Attorney's Office and an even newer member of the Edward Bennett Williams Inn of Court. And more than once, I can recall witnessing Larry pointedly critique a Justice Department official about the wisdom, or lack thereof, in his view, of the latest corporate enforcement policy. So today I'll provide an update on our efforts and tell you what's top of mind for us as we confront today's corporate enforcement landscape. And in honor of Larry, I no doubt will give you something to critique. Now, the bottom line up front is that we've been executing on the priorities that we set at the beginning of this administration, and our approach is straightforward. We identify the most serious wrongdoers, individual and corporate, and focus our full energy on holding them accountable. Those who break the law pay the price. Accountability promotes fairness, drives deterrence, and fosters respect for the rule of law. And at its best, it should also encourage investments in building a culture of compliance. That way, we're not simply bringing the cases, we're also building an enforcement framework that promotes good corporate citizenship. And this approach benefits everyone: consumers, investors, employees, and shareholders, of course, but also all Americans who deserve, and frankly, who demand, a criminal justice system that holds accountable those who break the law, from the street corner to the corner office. So, we're holding individuals accountable for corporate misconduct, we're demanding stiffer penalties for corporate recidivists, and we're using a mix of carrots and sticks to promote responsible corporate citizenship. And as we do all that, we are evolving to meet new and emerging threats from disruptive technologies, including one you may have heard a little something about: artificial intelligence. Now, our first priority has been and will continue to be individual accountability. Companies can, of course, only act through individuals. And the rule of law demands that those most culpable for a company's misconduct are the ones being charged, prosecuted, and convicted. And from the beginning, we promised to follow every corporate case up the company's org chart, no matter where the evidence took us. We also asked prosecutors to be bold, and they've done so. In just the last few months, Justice Department agents and prosecutors have secured convictions of the CEOs of the world's two largest cryptocurrency platforms, FTX and Binance. That's on top of convictions in the past few years of the chief executive officer and the chief operating officer of Theranos, two managing directors of Goldman Sachs, and dozens of executives across a range of industries, including investment firms, healthcare companies, and defense contractors, all charged and convicted of federal crimes. Now, this is challenging work, and as we investigate more complex schemes in more corners of the globe with more evidence to gather and disclose, we're inevitably devoting more resources to each individual case. And because we're bringing serious charges with significant penalties against senior executives, we're also taking more cases to trial. We're driving real accountability. We're also delivering consequences for corporate recidivists. A little over a year ago, we made clear that we would account for a company's civil, criminal, and regulatory history when considering an appropriate resolution. Now, of course, not all prior conduct is created equal, and not all companies are similarly situated. But we apply the same principle to companies that we have always done to individuals. A history of misconduct matters. After all, penalties exist in part to deter future misconduct, and they are not the cost of doing business. So when a company breaks the law again, and it's clear the message wasn't received, we need to ratchet up the sanctions. Take Ericsson, for example. When it breached its 2019 DPA, we refused to resolve the case in 2023 for anything less than a corporate guilty plea. Or take Teva Pharmaceuticals, for example. In 2016, it resolved an FCPA violation with a deferred prosecution agreement. And when the company faced investigation for price fixing in 2023, we demanded a more substantial penalty. And so for the first time, we made specific performance a part of the remedy. We required the company to sell off an entire product line. And this was a novel approach tailored to the company's unique circumstances. So if your company has had a recent brush with the law, now is the time to invest, and frankly, to reinvest in your compliance programs. I can assure you that the price of committing another violation will be far higher than the cost of preventing one. But the through line for all of our work and our enforcement framework is rooted in the time-honored understanding that people and corporations respond to incentives. It's human nature, and it's frankly what makes the business world spin. Now, I understand the challenges and the trade-offs that your clients face when managing an organization with thousands of employees, complex operations, and a Fortune 100 level budget. I know because I am the COO of one such organization. Companies fulfill their fiduciary duty to shareholders when they support behavior that rejects profit, or rather wrongdoing for the sake of profit, when they follow the rules and anticipate problems in advance, and when they reward pro-compliance behavior as well as pro-profit behavior. So, we've implemented policies to incentivize investing in a culture of compliance before the misconduct happens. Take, for example, our approach to clawbacks. Nothing focuses the mind like the prospect of a pay cut. And that's why the criminal division has been providing a dollar-for-dollar credit to companies that claw back or withhold compensation from culpable employees. It ensures that the actual wrongdoers are actually paying for the misconduct. We've also implemented new department policies on voluntary self-disclosure. Now, these policies are now consistent, they are transparent, and they're predictable. You see, we want to make the math easy. When a business discovers that its employees broke the law, the company is far better off reporting the violation than waiting for the Justice Department to discover it. Now, when the department does discover the violation, the company can still reduce its exposure by proactively cooperating in our investigation. But I want to be very clear about this. No matter how good a company's cooperation, a resolution will always be more favorable with voluntary self-disclosure. We've structured our voluntary self-disclosure programs to encourage companies to take responsibility for misconduct. And we've conditioned benefits on a company's willingness to step up and own up, requiring it to disgorge profits, upgrade compliance systems, and cooperate in investigations of culpable employees. That's good for everyone, especially general counsels and compliance officers. we want to empower them to make the business case for investing in compliance. And when they do, they can point to our policies. Now, the early reports on this work, I think, are promising. We've directed all the components across the department and the U.S. attorneys to implement self-disclosure programs. And we're seeing innovation on this front, as you'd expect from our very talented women and men across the Justice Department. Offices are starting to explore variations. At least 2 U.S. attorneys' offices, led by the Southern District of New York and recently the Northern District of California, are piloting initiatives that are, in essence, voluntary self-disclosure programs for individuals. They're offering non-prosecution agreements to certain categories of at-fault individuals who self-disclose wrongdoing and cooperate against other culpable targets. We look forward to evaluating the results of these pilots and determining what's to come later this year. So, as we work to encourage more reporting, though, we also want to engage traditional corporate whistleblowers, the people not involved in the wrongdoing, but who discover misconduct by others and who blow the whistle. Now, whistleblowing can take many forms. Take corporate acquisitions. Last October, we announced a disclosure program to incentivize companies who are engaged in acquisitions to surface misconduct in their due diligence and to report it. That way, we identify the wrongdoing and the wrongdoers. In these situations, the acquirer hasn't done anything wrong, and we want it to report the acquiree's misconduct so we can prosecute the responsible individuals, make victims whole, and rectify problems. Now, to be clear, this policy does not limit the department's very robust antitrust enforcement efforts. In fact, it complements them by ensuring that misconduct doesn't get swept under the rug. So I'm pleased to say that today we've codified this policy in the Justice Department's Justice Manual, including a key provision that it only applies to bona fide arm's-length transactions. Now, we've also recognized, though, that there's another way that we can encourage individuals to report misconduct, by rewarding the whistleblowers. And how do we do that? Money. Now, going back to the days of the wanted posters across the Old West, law enforcement has long offered rewards to coax tipsters out of the woodwork. And today we are announcing a program to update how the Justice Department uses monetary awards to strengthen our corporate enforcement efforts. Ever since Dodd-Frank created the whistleblower programs at the SEC and the CFTC, those agencies have received thousands of tips, they've paid out hundreds of millions of dollars, and disgorged billions in ill-gotten gains from corporate bad actors. But both programs and similar ones at the IRS and FinCEN, by their very nature, are limited in their scope. And QTAM actions, of course, which also offer whistleblowing incentives, are only available for fraud against the government. These programs have proven to be indispensable, but they really look a bit like a patchwork quilt that doesn't cover the whole bed. They simply don't address the full range of corporate and financial misconduct that the department prosecutes. So, we're filling the gap. Under current law, the Attorney General is authorized to pay awards for information or assistance leading to civil or criminal forfeitures. And in the past, we've used this authority here and there, but never as part of a targeted program. Now's the time to expand our use of this tool in corporate misconduct cases and to apply it to reward whistleblowing. So we're planning something new, a DOJ-run whistleblower rewards program. Today, we're launching a 90-day sprint to develop and implement a pilot program with a formal start date later this year. The premise is simple. If an individual helps the Justice Department discover significant corporate or financial misconduct otherwise unknown to us, then the individual could qualify to receive a portion of the resulting forfeiture. Over the next several months, we'll fill out the particulars, and Acting Assistant Attorney General Nicole Argentieri will discuss that process in a bit more detail tomorrow. But we've already established some basic guardrails. For example, we'd offer payments only after all victims have been properly compensated, only to those who submit truthful information not already known to the government, only to those not involved in the criminal activity itself, and only in cases where there isn't an existing financial disclosure incentive, including KETAM or other federal whistleblower programs. So, used proactively, this program will fill gaps. It'll create new incentives for individuals to report misconduct to the department, and it will drive companies to invest further in their own internal compliance and reporting systems. So, for all the potential whistleblowers out there listening today, you might be wondering what to look out for. Now, we will always accept information about violations of any federal law, just to be clear. We're especially interested, though, in information about criminal abuses of the U.S. financial system, foreign corruption cases outside the jurisdiction of the SEC, including FCPA violations by non-issuers and violations of the recently enacted Foreign Extortion Prevention Act, and, of course, domestic corruption cases, especially those involving illegal corporate payments to government officials. So, what does this look like in practice? Maybe you work, or more appropriately, your client does, at a fast-growing private startup here in the Bay Area, and you discover that your company's been paying bribes to get regulatory approvals and doctoring the books to hide the payments. If you come forward, you could get paid as part of the recovery from that criminal case. Or maybe you've got a client at a private equity firm, and she discovers that the CFO is forging underlying loan documents. Once again, if your client reports it, a portion of the recovery could be hers. So as we take this on, it's important to underscore a central aspect of all whistleblower programs. To be eligible for a reward, you have to tell us something we didn't already know, and you have to be first in the door. Now, this is key. And why is that? Because the same rule applies to the department's voluntary self-disclosure programs. When everyone needs to be first in the door, nobody wants to be second, regardless of whether they're an innocent whistleblower, a potential defendant looking to minimize criminal exposure, or the audit committee of a company where the misconduct took place. These incentives reinforce each other, and they create a multiplier effect, encouraging both companies and individuals to tell us what they know as soon as they know it. This helps us build the strongest criminal cases against the most culpable wrongdoers, and it helps us impose the most significant penalties on those who most deserve it, and it helps us, frankly, use our carrots to wield larger sticks. Now, with these announcements, our message to whistleblowers is clear. The Department of Justice wants to hear from you. And to those considering a voluntary self-disclosure, our message is equally clear. Knock on our door before we knock on yours. Today, though, there are more doors for us to knock on than ever. The global threat landscape is changing rapidly, and as always, we're evolving to meet new and emerging threats, including those from the malicious use of disruptive technologies. And now, the ultimate disruptive technology, artificial intelligence, looms larger than ever. Last month, in a speech at Oxford University, I laid out the department's focus on AI and its potential impact on our justice system. All new technologies are a double-edged sword, but AI may be the sharpest blade yet. It holds the greatest promise to improve our lives, but also great peril when criminals use it to supercharge their illegal activities, including corporate crime. So while we work to responsibly harness the benefits of AI, we are alert to its risks, and we will be using our tools in new ways to address them. To be clear, fraud using AI is still fraud. Price fixing using AI is still price fixing. And manipulating markets using AI is still market manipulation. You get the picture. We've long used sentencing enhancements to seek increased penalties for criminals whose conduct presents especially serious risks to their victims and to the public at large, like increased penalties for criminals that use firearms or other dangerous weapons. The same principle applies to the use or misuse of AI, where AI is deliberately misused to make a white-collar crime significantly more serious. Our prosecutors will be seeking stiffer sentences for individual and corporate defendants alike. And compliance officers should take note. When our prosecutors assess a company's compliance program, as they do in all corporate resolutions, they consider how the program mitigates the company's most significant risks. And for a growing number of businesses, that now includes the risk of misusing AI. That's why, going forward and wherever applicable, our prosecutors will assess a company's ability to manage AI risks and AI-related risks as part of its overall compliance program. To that end, I've directed the Criminal Division to incorporate assessment of disruptive technology risks, including risks associated with AI, into its guidance on evaluation of corporate compliance programs. Now, I also recently announced a new initiative called Justice AI, a series of convenings with stakeholders across industry, academia, law enforcement, and civil society to address the impacts of AI. And I'll be convening the first of those Justice AI discussions today, right here in the Bay Area. And we're going to use these conversations to inform the department's AI policy on a range of issues, including the corporate compliance issues I've asked the Criminal Division to consider. Now, in the coming days, your clients may want the scoop on what we've discussed here today. So before I wrap, let me give you the Cliff Notes version. First, we are continuing to execute on our core strategy, invest the most significant resources in the most serious cases, hold individuals accountable, and pursue tough penalties for repeat offenders. Second, we're using carrots and sticks to encourage companies to step up and own up and report misconduct to the government. With a first-in-the-door strategy, we're making it clear that neither companies nor individuals can afford to sit on evidence of wrongdoing. Third, we're designing our own whistleblower rewards program as part of our broader effort to fill gaps and innovate in this space, so stay tuned. And finally, we're applying Justice Department tools to new disruptive technologies, like addressing the rise of AI through our existing sentencing guidelines and corporate enforcement programs. I hope I've given you a clear picture of our enforcement priorities and what to expect in the coming months. And I trust I've also given you plenty of fodder for discussion in the days to come. Every day, we're working to ensure the Department of Justice lives up to its promise to the American people. Whether we're deploying old-school methods like flipping cooperators or responding to the newest game-changing technology, the women and men of the Justice Department will be unrelenting in our work to enforce our laws, the laws that protect jobs, guard savings, and maintain faith in our economic system. Thank you very much for listening, and thanks for having me here today.